Alright, am I connected? You know, I think I was gonna go, I wanted to go to the cop channel for this, but, I'm just reading out loud anyway. I don't really need a lot of response, so this channel should be fine. Living in a car with Travis Hines. So we're doing a live stream, and I just want to get the, oh, yep, yeah, right there. Okay. Oh, it shows. All right, all right. So this is a live stream that's going to be about cop stuff, and I want to read my lawsuit and just think of it out loud. So what do I want to do here? I'm in a live stream. I want to show the words. I want, yeah, the black and white. The dark. I want dark mode on. That's, I guess that's as good as it gets. All right, and then we'll split. It was when I have dark mode. Okay, it's only okay. Oh, speak up, really? Is it? I'm not hearable. Oh, hey, did it just show up? I just opened up the. Oh, okay. How does it look? Okay, all right, all right. Wow, look at that. There's everything. Well, okay. I don't really need um to show the chat, so we'll just move this off to the side. Um, Geez, I don't know. Make it bigger? Is this is this what I want? No, I don't think that's what I want. That's just the page. I don't want this. That's interesting. Okay, we're getting rid of everything because that's not what I want. Everything but the video. If I bring in this, okay, I'll put this little thing on my collar. I don't want to run. I don't want to run into it. I've been thinking about getting a bigger one. Be something fun to play with. Okay, so okay, the last window. I'm thinking, but if I do that, mm, I'd like to put it in black pad, but yeah, it's when it, well, if I put it in black pad is easier to read. Why didn't it open? Where's black pad? Come on. There it is. Okay. Maybe I should. Maybe I could just copy and paste it in black pad because it's so much easier to read that. So we'll go with black pad. Forget it. All right, and then move this. So copy and paste the whole lawsuit. Copy. Oh wait, no. All AC. Okay. To the black pad, and then we'll start at the top. That's the top. Yep. Oh wait, that's the bottom. There's so much. Uh, and would it help if I widthened it? Yeah, it kind of looks like it would. If I made it wider. Okay, then how does it look on? Ah, what's that? Okay, I see. It's um, yeah, I kind of want it to take up all that space. Whoops. There's really nowhere to. I could like. I want to make sure it's toward the top. How about like that? All right. So let's see. Let's just see if I can reach comments. I want to at least see comments offline. Pop out chats just off to the side or something. Right, it just disappeared. Top chat. How about just live chat? All mess. Okay. Right. Yeah, it's off to the side. Okay. Oh, wait. Turn your volume up, Mike. Oh, I see. What's going on with the drunk cruise? No clue what you're talking about, Travis. Not a pewter guy. Okay. All right. So I'm gonna read this out loud and just see how it sounds. So I'm writing a lawsuit to. I'm going to send it to. Okay, starting out, I'm gonna take this lawsuit and send it to the district courts right there. And they normally have a white screen. I got black. Um, and so I emailed the clerk, um, and she responded with an email telling me to I have to send everything initially by papers, and then I gotta pay $405. And I'd like to show that email. I think I could do that. Let's see. Jeez. Is that it? Okay. Just let me see if I can pull it up. The email. All right. Yeah, right there. And it's in the starred, so I guess I'll more, and it's in the starred. Okay, yeah, pro se. I'd like to show the pro se too. Um, I just this is what okay, and then her response. Now, I don't know if I want to show all of. It really doesn't look like there's anything sensitive here. Okay, yeah, there's really nothing sensitive in this email. But all right, I'll pull it up here, and yeah, let's see. Van Life goes for an eye exam this morning. Yeah, age is difficult. All right, I'm gonna open up that window. It's gotta be, nope, not that one. It's gotta be the lawsuit. Okay, and I don't know. Let's see what if I can expand, and then I want to, whoops, go expand. That's about as far as I can go. Look at that price, $402. Wow. All right, it's right here. So I just simply go to you go to the, what? I thought I could just click on her name. Oh, okay, well, it shows like that. Does that show up? The NDD clerk's office. You know how long it took me to finally realize that there's a district court that I could go to? I got down to Judge Trainer, the T's, through 6,000 lawyers. I didn't get all their emails because they've been blocking the judges. They started that maybe 6 months ago. But yeah, I get the trainer and I'm like, this guy's a district judge. And then I looked into that and I'm like, wow, there's a district. It's not just a county district. We're talking like a state district judge. And even though I got what 41,000 subscribers, nobody knows this stuff. It's just that hard of information to gather. So this is something that took me a long time to figure out. Going to just emailing lawyers, and I'm at T, or yeah, I'm at T for emails. I'm emailing lawyers daily. I'm getting terrible responses. There's absolutely nobody who, and I'm in the T's out of 6,000 people. There's nobody who's going to take it. I'll finish out my email list just so I could say that it's been done. But there's nobody who's willing to take it. There's one guy who kind of said he didn't think he could take it, and that's it. Everybody else has been just ignoring my emails or giving me out of office replies and or just straight up blocking me. We the people are in the car with Travis. All right. Let's see. The email now, is that visible? Oh yeah, it's right there. All right. Attached are forms which may be used to file a lawsuit in federal court. The packet provides instruction on how to complete the packet. The packet also includes information on how to file a motion to proceed in forma pauperis if you do not currently have the funds available to pay the filing fee. And I kind of do, but I question if I qualify as indigent for informal pauperis. It's not so much if I don't have the money on me. I have some money on me, but is there some kind of qualification that it could be approved for that would then um, qualify me? 'Cause she's saying in this email, if I don't have the funds available, well, I kind of do. So it's not a fair statement. But this is the clerk talking, not a lawyer. But yeah, $402 does take a big chunk out of my savings. But I do have it. The filing fee is $402. Be advised that the forms provided may not be proper for your specific legal situation. Please make an independent determination whether use of these forms is appropriate. The court must receive your documents in paper formats. Look at that. In paper, me emailing them. Is there anybody? That's the thing. I need to see if I could find somebody in Bismarck who can maybe walk down to the courts with. Well, how do you? I mean, I would want to serve the court. I would want to hand deliver to the court that paperwork. It's a little too cold this time of year for me. But I might be making a trip to Bismarck for this. I might be spending more time in North Dakota over this. But first, well, let me just read this. The courts must receive either the $402 or request the inform of pauperis before the lawsuit will be filed. Payments can be made by check, money order, or cash. I can just send cash through the mail. Do you wish to pay by credit card? Indicate this when you send your documents. Upon receipt of the documents, the court will contact you to process the credit or debit. See, they want to make it so easy to pay them, but they want to make it so difficult to send my arguments. We don't accept by email? And that's the thing. What I gotta know, like, why they won't accept it by email. It's like, why is paper so much more desirable than email? Is it because you want to make it harder on the public? Because I'm not a lawyer? I don't get it. So that's the filing, and then they gave me a PDF. Oh, I already downloaded it. I just wanted to open it. And I got a PDF. Oh, it's probably showing, huh? Yep, right there. General information. You're responsible for complying with the federal rules of civil procedure and the local court. Just wait a second here. Oh, well, I don't know. Let's take a peek. Okay. Employees of the court are not permitted to give me legal advice. Legal aid and attorney referral services are listed on the following page. Legal aid. So I don't think I'll be going to legal aid for anything. You're responsible for paying court fees. $402 for filing a civil action. and then they add an extra $101 for filing an appeal. This is also arbitrary too. What does that money exactly cover? 50 cents per page. That's what they'll get you too. 50 cents per page for copying, because they'll want you to make multiple copies. All communication to the court should be in writing. Oh, you can't just call them up. And directed to the clerk of court at an address listed above. So Fargo or Bismarck. In writing. And they're saying that I should be writing them paper letters. They only want to communicate by paper. And then what do they? I bet they got somebody at that courthouse scanning all that paperwork into an electronic system. It's like so inefficient. Uh, it's still not going to stop me from trying to send them a PDF as a non-lawyer, and then questioning why they can't accept PDFs. Why can't you um, uh, enter the modern times? What's the deal with the court? What's the disconnect there? Before filing a civil action, consider the consequences of losing or filing a frivolous lawsuit. Kind of like what the prosecutors did with my case. But what were their consequences, huh? How about before filing a criminal action, consider the consequences of losing or filing a frivolous crime? All right, where's that? They don't have to consider the consequences. Can you believe that? Under limited circumstances, the court may order that the losing party pay the attorney's fees. And I asked for money when I sanctioned my prosecutors, but they didn't agree on anything. They made me lose money. Pay the attorney's fees and costs incurred by the winning party to defend a civil action. Let's see, what are people saying here? I'm sure there's email is proof in court. Yeah, it's just good enough proof. I don't know why they have to be so anachronistic. See if you can fax it. Oh, a fax. Yeah. I mean, how far did they skip? Maybe their time period skipped the fax. They want to work in Victorian times, sending letters. But yeah, I mean, they can accept money through the check card. They're happy to accept that money uh, through a fast, convenient means. Definitely mail it, certified mail for proof of certified mail. The best certification is hand delivering it straight to them. What I need is a courier. I wonder if there would be a courier business in in Bismarck that can hand deliver this paperwork to the courts, or just anyone. Get a get a courier service, and then they could record it. Tell them to record them handing the paperwork, and then that'll really secure the evidence. You got to gather evidence. You're still in the process of gathering evidence as you're trying to uh, sue the city. You're also gathering evidence for the process of it all, so they can't say that you didn't do something. Um, Fan Life says it's like text versus a phone call. I don't remember the phone call, but you got me if it's text. Yeah, they don't want you calling the clerks. Do they have a phone number up there? They don't. They say come on. All communication to the court should be in writing, and they put a telephone. Direct it to the clerk of court at the address listed above. When did they write this? I mean, it's in digital format, so I mean, clearly they've caught up with technology. But the instructions, at least the instructions have caught up with technology. But what about the process? They weren't they just, gosh darn it, they haven't been able to get the system working properly, so they have to fall back on paperwork. That's so unfortunate. So communication should be in writing, but they do leave a phone number. So if you call them at Fargo or Bismarck, they'll be like, "What are you calling us for? You're supposed to follow the instructions and write." Because and then without explaining why. They don't need to explain. They just say these are the rules. You follow them, or you don't get, or the citizen. These are the rules for the citizen. The citizen must follow them, or the citizen doesn't get to enjoy their free expression in government. If you don't follow the rules, you don't get to enjoy. You don't get to pursue your free expression, your freedoms in the government. So I'm filing a complaint. Review the federal rules of civil procedure and local rules of court. How's this showing? Yeah, I still got the. I suppose I could make it bigger. How about a little bit bigger? All right, and okay, federal rules. So I need to read federal civil procedure, local rules of the court. I'm kind of aware, and it's like, yeah, I could sink, I could start suing Williston, and then getting familiar with the rules, and then waiting for Williston to screw up so I can sanction them again on the defendant end of this process. I sanction them on the prosecutorial end, and it'd be really funny if I could find a way to sanction them. I start the lawsuit, and they do something stupid, which, I mean, this is Williston, so, I mean, there's a chance. I've already discovered a simple way with the email process. There might be another opportunity to file a sanction against them on something else with the court rules that they didn't follow. Because they're just winging it in Williston. They don't care. But they're certainly playing the hard game with people, trying to just uh, like overwhelm, just playing a real tough game against people. Complete a cover sheet, Form JS 44, and attach it to the complaint. And I mean, I'm kind of familiar with the cover sheets. I think, at least with Williston, that's the cover copy or something. It's to to acknowledge that you sent the sheet, the paperwork or something. Send the filing fee or complete an application. Clerk will issue a summons. Okay, and then there's a lot more. Service of summons. Review Rule 4. Federal rules, civil procedure. I'm sure and that's the thing. I was gonna say, Williston, probably. I want to tell Williston ahead of time that I intend to go through with this. This is my. I don't. Who do I email exactly? Who do I email to really give a clear warning? So, I think I want to email the mayor. I think I want to email the mayor, Mayor Klug, and be very upfront about what I intend to do. This is my lawsuit, and you see everything in the lawsuit, what I intend to do. I'm going to give you some time to respond to me. And being Williston, they're not going to say a darn thing. They're just going to want to let it flow like the oil. You just be quiet and let the oil flow out of the ground. Don't say anything, because secrecy is what's gotten them by for all these years. Secrecy in this oil trade, keeping things under wraps as much as possible, and suppressing any little violations as much as possible. They got the newspaper wrapped around their fingers, all of their fingers. Every newspaper, each newspaper and news source is wrapped around each one of their fingers and toes. Everything is wrapped up. They got it covered and sealed with oil. It's just incredible. So they'll be quiet. I still want to go through the process because I understand that's courtesy. That's common courtesy. Okay, what am I doing here? All right, references and libraries and terms. So exciting stuff. What's all that? We'll just look at a couple. Terms are may encounter when filing complaint, cost, defendant dismissal, diversity of citizenship. A federal question. Yeah, so that's. I'm doing informal. I'm going to try informal papyrus. And the bottom. Oh, this is a. This see, I wrote mine kind of like this, but I didn't see this jury trial demanded at the top. They really want to know right away. So I don't need to say. I don't need to check. I can just write this in my kind of my own format and put jury trial demanded. And that's what I did not do. Okay, we'll just look here. Sample complaint plaintiff for each plaintiff, and I just did that seeing this. Oh wait, no, that's me. For each plaintiff. Yeah, that's me. And then I put the defendants. And yeah, they want the name and address. Okay, sure. I see. That's what I didn't do is I want to put the police station, the courthouse. State the facts. Include your name of each person and dates and places. Be specific. Yeah, I got things to work on with that. I keep going back to it time and again, and it's a slow process. Administrative procedures, if applicable, state whether your claim was heard by any administrative agencies. What? State whether your claim was heard by administrative type, the type of proceedings, the date and place, the outcome. Well, okay. I mean, yeah, I want to email the city, so I guess I would at least put that as a warning. I want to say in my lawsuit that I did email the lawsuit to the city and then I don't know, wait a couple of weeks and then write as an additional statement in my lawsuit that I sent a previous version of the lawsuit to the city. All right, signatures, civil cover sheets. Oh, this is the cover sheet. Okay. And I don't even think that's going to be readable on the screen. Yeah, it's citizenship of principal, basic jurisdictions, all these tiny check marks, forfeiture, bankruptcy, I guess. Instructions for attorneys. So there's a lot to read. I probably should get familiar with that. This is only page 9 out of 12. Application to proceed in district court without prepaying. Oh yeah, then I want to fill that out and see, because that's like number one. Okay, 2 steps before I send out the lawsuit is see if they consider me qualified for being poor enough, and then give Williston the warning. Fire off the Williston warning. So that covers the information in there. I can get out of it. And then let's take another look at the. Is this it? Nope. Then it's this. The lawsuit itself. Okay, that's the top, so I can get rid of that. Get rid of that. And I don't know, bring it down a little bit. Not much though. Yeah, there's not much room for video. So, well, let's see what people. So I got a lawsuit here. Email everybody. Yeah, I probably could do more than just a mayor. He might be out for a couple of weeks. Who knows? He can barely walk, so he's not the healthiest guy. Send Williston a bill for service rendered to see if they pay it. Yeah, I guess I could kind of send them a bill, but also say if I don't get the bill, then the lawsuit's going to follow. They never respond. It's amazing. Alright, officials acting on behalf of the municipality of Williston, defendant, deprivation of civil rights, case number. Alright, and these are all the defendants I want to bring forth to answer for their crimes. The Jesse Cruz, Christina Hilgarts. I don't know court clerk Kathy's last name. Judge Xander, and that other judge too, I forget his name. The prosecutor, I'll stick with one prosecutor. Kendra, I forget her last name now, it's changed since she got married. From Kendra Engett to whatever, Richardson or something. Court clerk Jody Fixon, because I mentioned Fixon and she's more broken. I'd name her Jody Broken Fixon. The way she conducts herself in the clerk office. Procedural history and facts. Mr. Hines was unlawfully arrested for resisting arrest within the first hour of his arrival at the library in Williston on July 16th and incarcerated for 5 days. After Mr. Hines' arraignment hearings, he was held in incarceration for another day until the judge guards finally allowed him to call a bail bondsman on July 20th. Following that, Mr. Hines was released on bond. 6 days later, on July 27th, Mr. Hines was arrested again over the same incident with an added criminal charge of disorderly conduct. Mr. Hines' first arrest cost around 10% of his total estimated life savings to bail out. Later, his second arrest cost another extra 20% of his estimated life savings at the time. Within 10 days, Williston had extorted approximately 1/3 of Mr. Hines' security life savings. Personal? How about personal? Maybe personal life savings. Now I gotta change that, which shouldn't be too hard. Let's see. Judge Xander lowered the initial $750 bond down to $250 should I say at arraignment? Arraignment, which is a drop of 33%. The bail bondsman, 10-minute bail, further charged $150 that increased Mr. Hines' $250 bond payment by 160% up to $400 to be freed from jail, with the added bail fee of $150. The drop in Judge Sanders' bail only amounts to 53% drop from the $750 municipal bail. I just want to make it clear that there's, oh, my foot hurts. That there's okay Google, how do I fix my foot?
Here is some information for what to do about foot pain. Here's a summary from the website webmd.com. To treat it, change to better fitting footwear. Do stretches for your toes and toe joints. Try shoe inserts. Ask your doctor about surgery. 1. Change to better fitting footwear. 2. Do stretches for your toes and toe joints. 3. Try shoe inserts. And 4. Ask your doctor about surgery. People also sometimes ask me, what is the main cause of foot problems? Do you want to hear the answer?
Yes.
On the website mayoclinic.org, they say, injury, overuse or conditions causing inflammation involving any of the bones, ligaments or tendons in the foot can cause foot pain. Arthritis is a common cause of foot pain.
Man.
Injury to the nerves of the feet may result in intense burning pain, numbness or tingling.
Burning. Oh, it is burning. It's one toe that kind of hurts. Alright. I think it's how I'm sitting too. Alright. Let's see. Judge Xander, lowered the bail, increased Mr. Hines's, with the added bail fee of $100, the drop in Judge Xander's bail only amounts to $50. Okay, and then we'll go up. She successfully maintained a $250 bail to be released from jail, even after reviewing the single criminal charge of resisting arrest. Judge Zander said that she don't normally issue PR bonds, and I'm quoting her exactly on that. Even after giving a defendant before Mr. Hines a $0 PR bonds for similar circumstances. Now, I don't even know the circumstances. Judge Zander did not debate the lawful nature of Mr. Hines's arrest. It's really, it's too bad that, that they got to deal with um, the municipal court on misdemeanors. See, Scrycraft says, "Oh, my toe. Yeah, my toe is kind of hurting. I wonder if I should be standing. That's it just bent the wrong way or something. Jeez. It doesn't require you to file with the court. Serving defendant. All right. So, all right. Going on. Even after giving defendant before. Okay. While handcuffed in the back of Officer Cruz's police vehicle on. Here we go. On July 17th, Mr. Hines' life was put into jeopardy as Officer Cruz drove Mr. Hines to jail. Officer Cruz appeared to be trying to multitask in a distracted manner while driving, which is visible on his body cam. He was fumbling with Mr. Hines' ID, computer, and various other things. At one point, Officer Cruz dropped the ID. I put that in there. Also, Mr. Hines' right hand was noticeably swollen after the painful handcuffs were removed after almost an hour of wearing them. Officer Cruz told Mr. Hines that the cuffs were properly secure, but that his wrists were too big. So insulting. On July 27th, Officer Hilger illegally searched the contents of Mr. Hines' voice recorder without any permission or known search warrant. The search went above and beyond any search incident to arrest. And how about also something like also it went above and also it invaded the protections set forth by our Fourth Amendment rights. No probable cause was expressed by Officer Hilgert. Officer Hilgert's actions are observable on his body cam. Officer Hilgert claimed that Mr. Hines was illegally recording in the courtroom. At, yeah. As Officer Hilgert sat in the courtroom and waited until after Mr. Hines was done with his court appointment before arresting him on the second time, maybe on the second time. Officer, yeah, I'm insulted by being told I have big wrists. I'm sensitive. Officer Hilgert left Mr. Hines upon arrival in the WCCC garage fully clothed in his hot patrol car on July 27th with the ignition shut off and walked away for 20 minutes. The garage did not have an AC. Mr. Hines' health was blatantly disregarded when his life was in clear danger from the rising temperatures in the vehicle due to the greenhouse effect. Temperatures were hot that day in the mid-80s. The lack of the air circulation made things worse in that time frame within the car and within the garage. Mr. Hines was denied a Sixth Amendment right to a court-appointed attorney by Judge Janet Zander on July 25th. In spite of qualifying for an indigent attorney, Judge Zander believed that Mr. Hines had enough money to represent himself. Again, a week later, on July 27th, Mr. Hines requested to have a court-appointed attorney present and was again denied by Wilder. That's his name. Let me go back to the top. I think it's kind of worth mentioning Judge Wilder. What was his first name again? I'll put at least his last. Chuck, right? Chuck Wilder. Jerk Wilder. Call him Jerk. Jerk number 1, jerk number 2, jerk number 3. They should know who I'm talking about. Speedy trial pushed the limit. Alright. Furthermore, Mr. Hines' Sixth Amendment right to a speedy trial was pushed to the limit at 11 months from various administrative reasons and obstructions. For example, Prosecutor Taylor Olson delayed her responses to Mr. Hines' motion, violating court rules. See, I'm mentioning this in another paragraph. How do I get that? I'm kind of repeating myself. I don't want to do that, but 9. I gotta do something about that, but I don't know what. Mr. Hines is subjected to the Eighth Amendment rights violation for daily 23.5 hours of lockdown, isolation, and silence from jail for 6 days. Also, the jail placed Mr. Hines on a starvation diet, stressed that Mr. Hines was not. I wasn't comfortable with starving, and Mr. Hines lost significant weight and strength. Video exists of the encounter at the library between Mr. Hines. Video will be submitted to the court in the format required. CDs? Will it be a CD-ROM? Yeah, I don't want to repeat myself. Alright, so we got Officer Ravaska conspired with the librarians on July 16th to add another criminal charge of disorderly conduct, more to support their unlawful resisting arrest charge than to serve the public's greater interest. This is a 14th Amendment violation that was conspired against. The amount of time it took to determine, I don't know if I said that right. The amount of time it took to determine and decide upon a later disorderly conduct charge goes beyond any reasonable length of time for an investigation into such a criminal issue. Usually this kind of charge can be determined much more quickly when all parties involved willingly. I don't know what I'm saying here. Sergeant Ravaska's actions look like retribution more than practical police policy. Yeah, the amount of time it took to determine and decide upon a later. Oh my god. I don't know what I'm saying here. I gotta break that off. The amount of time it took to determine and decide upon a later disorderly conduct charge goes beyond any reasonable length of time. I don't know what I'm saying. The amount of time it took to determine and decide upon a later disorderly conduct charge goes beyond the amount of time it took to investigate. To investigate the amount of time it took to investigate the disorderly conduct charge goes beyond any reasonable length of time into such a criminal issue. That's pretty general, but usually this kind of charge can be determined much more quickly when all parties involved willingly. I don't know. It's usually what? I don't think I should be saying that. I don't know what I was saying there. Sergeant Ravaska's actions look more like retribution than a practical police process. Something like that. According to according to the description by 18 U.S.C. 242, the municipality of Williston acted under the color of law. Multiple times the defendants deprived Mr. Hines of his right secured by the Constitution. from the first arrest to the courtroom, clerk office, and the city prosecutors. The defendants acted willfully, knowing that they stretched and twisted their. Can I say that? I mean, you could say anything. You listen to a lot of these lawyers. But how did they exceed all need to inquire further? I don't know. The municipality acted, okay. There's rights, courtroom. Let me just, okay, oh, just trying to look at something here. Yeah, alright, there and there. Um, Deprive Mr. Hines of his rights secured by the Constitution from the first arrest to the court. Oh, yeah. They acted, stretched and twisted their rules and laws to enrich themselves. Defendants caused pain, anxiety, time loss, and loss of money to plaintiff. That's not really an argument. That's just setting the tone. And you gotta question how. This is an arrest case that needed to be solved as a matter of law at the first arraignment hearing. It wasn't. Instead, the prosecutors, Taylor Olson, Kendra Engett, unlawfully pushed the criminal charges as a criminal case to be decided by a jury. Unlawfully. This was prosecutorial misconduct and judicial misconduct on the municipal level. Our civil rights are non-negotiable and cannot be infringed upon. The Williston municipality officials failed Mr. Hines in his civil social contract. Mr. Hines visited the library like he has visited hundreds of libraries before and was vigilant for any signage upon. Oh, now I'm making an argument. See, the thing is, people want to know like the backgrounds, and you can put the backgrounds in the lawsuits. It doesn't exactly hurt. Vigilant for any signage upon entering that could have been unique for this library. There were none. Mr. Hines followed the rules set forth by the city and up as best he could. But if the local city policy is unreasonable, then it must be reviewed in the light most favorable to the plaintiff making the claim. What claim? But if the local city policy is unreasonable, the claim of making the claim of like prejudice? Prejudice? Is that right? The claim of I would just kind of stick with prejudice right now. Okay, Google, what's thesaurus prejudice?
Here's some information from the web that might possibly help. On the website merriam-webster.com, they say, some common synonyms of prejudice are bias, predilection, and prepossession. I also found an answer to this question. What are antonyms for prejudice? Do you want to hear it?
Yes.
On the website synonyms.com, they say, prejudice, antonyms, judgment, fairness, impartiality, advantage. Synonyms, prepossession, prejudgment, predisposition, bias, unfairness, injury, harm, impairment, detriment, partiality, disadvantage, damage.
Claim of harm? The claim of harm and prejudice. All right. Oh yeah, yeah. I'm still in Springfield. I'm gonna be here for a couple of days, I think. Just messing around. I'm a little scared to explore too much. I mean, I'm kind of tired today. I was thinking tomorrow I wanted to go check out the city a little bit more, downtown. Go on bicycle and see what's around there. Just for one day, that's all I would need. If the Williston police truly believe that the level of peace that Mr. Hines disturbed was truly a criminal offense, then the police should have arrested the entire is that, I was feeling upset about this before, but I'm like, nah, maybe I don't need to be making this argument. The level of peace disturbed. The police should have arrested the entire audience of the baseball game happening across the parking lot as occurring at the same time of Mr. Hines' arrest as well. Its orderly conduct ordinance is supposed to be evenly enforced across the municipality. I don't know, I'm trying to make the point that it's not fairly enforced. What's the best state you've been in? I don't know. Northern California, on the coast. Not further inland. The Williston police are tasked with enforcing an ordinance that is superseding the North Dakota Code. However, the police have strayed even further away from the groundings of their ordinance and are experimenting with cultural enforcements. Officer Cruz made a comment to the library director that Mr. Hines should not be acting the way he did. The Williston Disorderly Conduct Ordinance seems to provide a cushion for the police to make arrests that may be lawful in the municipality but are not lawful in the states. The North Dakota Supreme Court has argued that there are limits of disorderly conduct. There are protections. How about... Okay, there are limits of disorderly conduct enforcement, such as to fighting words that tend to incite an immediate breach of the peace. On multiple cameras throughout the scenario, at no time did Mr. Hines engage in disorder conduct. I don't know. At no time, I don't want to be fighting the criminal. On multiple cameras throughout the scenario, it is clear that Mr. Hines was acting within his constitutional rights. Was acting within the limits of his constitutional rights. Maybe something like that. Officer Cruz and Ravaska made an arrest on a secondary charge that doesn't... Okay, Google, what is a criminal secondary charge?
Sorry, I don't have any information about that.
Because you're stupid! Secondary charge. Not even Google knows what a secondary charge is. California would be my worst list. Oh, on the coast? Are you sure? No, I'm not speaking of Eureka. Wow. Anywhere outside of Eureka, for sure. Let's see. Show me state. Do it during the daytime, no night time around there. Okay. Handbell says, look at HBO Matt and Matt Rinkin. He won $75,000. There's a PDF file of his winning. Yeah, I've heard about HBO Matt. What happened when I looked last time? Did I miss something? I'll take a peek. Oh, that's okay. Okay, I'm just gonna look a little offline here. Just Leon Valley police attacked me at City Council. That's HBO Matt. And then he's got videos. Tents for Haitians. 2 months ago. Yeah, I looked at it before. I'm not really seeing anything here. I think it's got to be like specific.